Hi, my name is Jessica, and I am presenting on behalf of Team 5 on the topic of the Patient Protection and Affordable Care Act. The objectives of this presentation are to help the audience gain a greater understanding of the key provisions of the PPACA and the key legislative enactments that address discrimination and harassment in the U.S. healthcare system. So what is the PPACA? The Patient Protection and Affordable Care Act has two main goals: to protect patients from unfair and discriminatory insurance practices, and to make access to health care more affordable for all Americans. The PPACA has what is called an individual mandate, a requirement that all Americans must enroll in health insurance. This has been extremely controversial and has been challenged in the courts. As of October 1st, 2013, the PPACA's health insurance marketplaces opened online for U.S. citizens and small businesses. These exchanges allowed individuals to compare and apply for one of four tiers of health insurance that would best fit their needs based on what they could afford and the benefits they wanted. Tax credits and subsidies were offered to those who met certain income requirements through the marketplaces. Exchanges could either be run by the state or federal government. However, only state-based exchanges were allowed to grant subsidies to those who met income requirements. The court case Halbig v. Bureau challenged whether or not federally run marketplaces have the right to offer subsidies to individuals who qualify. This will continue to be an issue in the future due to conflicting rulings and a lack of clear answers as to whether or not the federal government will have the right to offer subsidies within individual states. By 2014, anyone who has not enrolled for insurance either through their employer or through one of the marketplaces will have to pay a penalty on their income taxes. Affordable care organizations were established by the PPACA and have the greatest potential to offer quality care while keeping costs low. The PPACA established Medicare's Shared Savings Program, and with the new provisions, Medicare groups will now have to work hand in hand with ACOs to reduce the cost of care while maintaining quality of care. Important legal issues that have arisen during the implementation of ACOs include price fixing by healthcare providers and physician self-referral, both of which try to increase profits in favor of organizations. The anti-kickback statute and antitrust laws have been applied to ACOs in order to protect consumers from these sorts of practices. With these consumer protections in place, ACOs have the greatest ability to lower healthcare costs by eliminating redundancy and overlap. The federal government gives ACOs the incentive to decrease costs below the risk-adjusted benchmark for Medicare beneficiaries by offering a share of the savings directly to the organizations themselves. The future success of ACOs will depend largely on their ability to invest in new technologies and advance the quality of care without increasing costs. With the help of the PPACA over the next decade, the nation's deficit will be reduced by $143 billion. To prevent the PPACA's benefits from causing additional deficit spending, the law contains several provisions that raise revenue in new fees and taxes, which will yield roughly half of the savings. Increases in Medicare payroll taxes, taxes placed on Cadillac insurance plans, is estimated to raise another $4 billion by 2017. Although federal costs for implementing PPACA will be huge, Americans will be able to decrease their per capita spending on healthcare, which will end up saving much more in the long term. States will be able to save money by creating their own exchanges. A medical loss ratio is the percent of a consumer's premium that an insurance company can spend on direct patient costs. If an insurer spends too large of a percentage of it on administrative costs instead on the patients, the remaining amount will be refunded to the policyholders. Supporters of the MLR state that is an effective means to control healthcare costs by limiting the amount of money insurers can spend on administrative fees. As evidence of the effectiveness, rebates have helped 12.8 million policyholders by refunding nearly $1.1 billion to consumers as of August 2012. With the PPACA, Medicaid eligibility limits increased so that individuals and families earning up to 138% of the federal poverty level will be eligible. Eligibility for expansion is decided on by a state-by-state basis. Instead of a complicated set of eligibility criteria based on assets and resources, eligibility will be determined based on applicants' modified adjusted gross income from their most recent filed federal tax filings and how many people are in their households. 4.3 million residents in the United States that are expanding Medicaid coverage will gain access to affordable health insurance. An implication of Medicaid expansion is that patients may have difficulty finding a primary care physician who is willing to accept Medicaid patients due to low reimbursement rates. There is also the case of not having enough physicians to provide for the millions of newly insured patients. Due to the choice of opting out of Medicaid expansion, states refusing to expand will leave 5.7 million Americans uninsured. Essential health benefits are an important provision under the PPACA because so many insurance companies were not previously providing adequate service for their consumers. Insurance policies must now include items and services within at least 10 categories, including emergency services, maternity and newborn care, mental health and substance use disorder services, prescription drugs, and preventative services. However, there are still limits. For example, insurance companies can still put a yearly dollar limit and lifetime dollar limit on spending for healthcare services that are not considered absolutely essential. In 2014, reinsurance payments from the state to cover high-risk enrollee costs totaled over $10 billion. And through this program, these costs decreased to less than half by 2016. States are independently responsible for implementing their own reinsurance programs, and if a state elects to not adopt a reinsurance program, the Department of Health and Human Services will establish and perform all reinsurance functions of the program. The Risk Corridor program helps give certainty to premium costs by sharing an insurer's losses and gains while reducing inappropriate rate setting. The Risk Adjustment Final Rule under Section 1343 of the PPACA applies to qualified health plans and prevents against risk sharing or the transfer of. The rule applies to non-grandfathered individual and small group plans inside and outside exchanges that provide payments to health issuers from high-risk populations and provide a permanent risk adjustment. It also helps transfer funds from plans with lower risk enrollees to plans with higher risk enrollees to protect against adverse selections. One of the most important challenges to the PPACA was the National Federation of Independent Business versus Sebelius. This Supreme Court case questioned whether or not this widespread federal reform of the PPACA would trample on the rights of states, as well as whether or not the PPACA would be able to require individuals to sign up for insurance, otherwise they would be subject to a mandatory tax. The Supreme Court would side with the states and said that they would not lose pre-existing Medicaid funding if they opted out of expansion, and then they maintained that the tax penalty levied on individuals who did not enroll in insurance was indeed constitutional. The Civil Rights Act was established in July 2, 1964, where it was signed by President Lyndon Johnson. The purpose of the Civil Rights Act was to prohibit discrimination based on race, color, religion, and national origin. These laws are designed to treat individuals with respect and equality. Examples of these include freedom of speech, right to vote, and the freedom from involuntary servitude, or slavery. It is illegal under Title VI of the Civil Rights Act to deny coverage to an otherwise eligible individual based on their race, color, or nationality. This would apply to government programs like Medicaid or Medicare, where individuals have to apply for benefits. Title VII of the same law forbids discriminatory employment practices based on race, color, religion, gender, national origin, or pregnancy. This act can apply during the process of hiring, dismissal, and promotion in employment. The Civil Rights Act, Section 1981, it protects both white and non-white persons against racial discrimination. The Supreme Court has decreed that Section 1981 also prohibits the government from discriminating against someone based on their citizenship status. Section 1983 is the Civil Action for Deprivation of Rights Act and was enacted on April 20, 1971. This was to provide a civil remedy against the abuses that were being committed in the southern states, especially by the Ku Klux Klan. The federal statute that enables you to file a civil action for deprivation. Lastly, Section 1985. This section prohibits two or more persons from conspiring to deprive any person of the equal protection of the law. This section creates no substantive rights, but provides a cause of action against two or more persons who engage in discriminatory contact prohibited by other law. In conclusion, the Patient Protection and Affordable Care Act sets key provisions to the U.S. healthcare system. And through its key provisions, the PPACA sets out to give Americans two things: affordable care and increased protection from unethical and discriminatory health insurance practices. But the implementation of the PPACA will be a long and drawn-out process, complicated by political pressures, public debate, and legislative proceedings. As employers, individuals, and insurance companies have different roles to play in this process, and their goals often conflict, the federal government will increasingly be forced to intervene between them.